Okay, we're going to start talking about the actual Constitution, some of the principles and tenets of the Constitution that we will reflect on and talk about for the rest of the semester. So here are our objectives for this particular lecture. We want to look at the different principles contained within the Constitution, and I think I've outlined about 9 of those. Want to differentiate between the different articles that are in the Constitution. We are also going to say a few things about how to amend the Constitution, point out some of the key amendments, and then lastly, it's not on the objectives, but I'm going to say a few things about how the Texas Constitution differs from the U.S. Constitution. All right, so just thinking about the Constitution, we know from previous courses, I'm sure, that the power of the federal government was put into 3 different branches of government. We have what is called a bicameral legislative branch, where we have the House and the Senate. Remember, bicameral just means 2 houses. They pass laws. The executive, or the president, is going to enforce the laws, and the judicial branch, the judicial branch enforces the laws, and therefore we have a separation of power between the different branches of government. So if we think about how to view the the Constitution, one way is to think about a horizontal view, the separation of powers, where you have the executive, legislative, and judicial branch all checking on the powers of each other. So we have a separation of powers and a checks and balances, and I'll say a few more things about that momentarily. The other way to think about it is a vertical view, where we're going to talk about federalism in the next week. So federalism basically refers to the idea that you have 2 levels of government, one at the national, one at the state, and their powers overlap and they share some powers. And so those powers given to the national government, we refer to them more as enumerated, and those powers that the states have are called reserved powers. But we're going to focus on the horizontal view today, and then next week we'll talk about the vertical view, or that of federalism. All right, so let's just look at these different constitutional principles. The first is the separation of powers. And again, this is the idea that we have these 3 different branches that are working independently but yet together in order to carry out, enforce, and legislate. There's the argument that sometimes the government is too slow to act because of this separation. If power were located primarily in one branch of government, things might be done more quickly or more efficiently. And sometimes this separation of powers affects our foreign policy decisions. If we think about the president going to the Congress to ask the Congress for certain concessions in order to, for example, put troops on the ground somewhere. But we also see this in terms of natural disasters. Think about the aftermath of Hurricane Katrina, where you have the federal government slow to react to what's going on in New Orleans, mainly because this is a state issue in terms of recovery, and the state has to ask the federal government for help. And so there is this idea that the 2 levels of government, whether you're talking about federalism or if you're talking about the horizontal view with the different branches of government, that this separation of powers calls for a slower, more deliberate form of government that sometimes it's difficult to react to crisis situation. And here we have the different types of things that these different branches of governments do. So the legislative branch passes federal laws. They are in control of federal appropriations. An appropriation simply means the ability to spend money. They deal with treaties and presidential appointments. Keep in mind that's just the Senate. The legislative branch is in charge of interstate commerce. That is, how do we deal with commercial trade or any other type of commerce between states, such as that between Texas and Oklahoma or Texas and Louisiana. And the legislative branch established all the lower court system at the federal level. We'll talk about this a lot more when we talk about the judicial branch, but the only court that the Constitution creates is the Supreme Court. It was Congress's job to create all the other courts. The chief executive, the president, his job is to enforce the laws that are passed by the legislative branch. He's also considered the commander-in-chief. He gets to make treaties that the legislative branch will approve. He can propose some laws, and then the legislative branch comes along and formulates those. He has appointment power when it comes to federal judges, and he has the power to pardon individuals who are convicted in federal court. And in the judicial branch, it has the power of judicial review, where they look at lower court decisions to see if they're constitutional or if they upheld the Constitution. They can look at acts of Congress and declare them constitutional or unconstitutional. And if one state wants to sue another state, then that particular type of case has to go to the federal judiciary. So that's a brief look at the separation of powers. Of course, each one of these branches has the ability to check and balance the powers of the others. And so I'm sure in one of your civics classes at some point in time you probably made a chart or some sort of poster about how each branch of government checks the powers of the other. So here's one example about the different ways that each one of these branches checks the powers of the other branch. And you can print this out. It's on the notes that if you print out the PDF form of the lecture notes so that you can look and see these particular types of checks and balances. So I'm not going to go over those individually with you. All right, a third principle, if you will, is what we call the constitutional principles of, or an additional constitutional principle is the idea of popular sovereignty. So if you see the preamble to the Constitution, here it reads, "We the people of the United States of America," in order to form a more perfect union. So this third principle is popular sovereignty, or rule by the people. And again, the term popular sovereignty simply just means the people have the right to rule. All right. A fourth principle is that of limited government. The idea that the powers of the government are limited by the Constitution, but government was not limited as much as people would have liked to originally. That's why we have the Bill of Rights. So it was when the Bill of Rights came along that we had much more of a limited government. But the Constitution specifically prohibits two particular types of acts. One is called ex post facto laws. And the ex post facto law is the idea that you can't pass a law today to prosecute me for something that I did yesterday. So for example, if I am driving down the street and there's no stop sign, and so I go through an intersection but a stop sign is there the next day, the police can't go back in time and give me a ticket for not heeding that stop sign. Okay. So that's called an ex post facto law. The other type of law is called a bill of attainder. And the picture of the Time magazine is just an example of ex post facto laws. The idea that this is a picture of Julian Assange, who is part of the WikiLeaks, or the director or founder of WikiLeaks. And there were many people who wanted to try him for some sort of treason or otherwise, uncovering government secrets. But there was no law about that. So in terms of what he was specifically doing. So we can't go back in time and create a law to make him somehow culpable for a particular crime. A bill of attainder is a law which declares someone to be guilty of a crime without giving them the benefit of a trial. And so a lot of people wanted to convict, if you will, Acorn in the news during the last election cycle without giving them a fair trial. So a bill of attainder means that you're going to throw someone in jail without the benefit of a trial, and we don't allow that in the United States. But the limits of government in other areas weren't specifically written down. So example, in the Constitution itself, there's no mention made of freedom of speech or freedom of the press in the original Constitution. These would be listed later in the Bill of Rights. All right, a fifth constitutional principle is that of federal supremacy. And this is set forth in Article 6 in the second paragraph that says, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all the treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land." So therefore, if you're asked what the federal supremacy law says or what the supreme law of the land is, it's the Constitution, the laws of the United States, and any treaties that the United States makes. Therefore, if there is a provision in a state constitution and or state laws that conflict with the federal Constitution, then those are going to be deemed unconstitutional and therefore invalid. So federal supremacy, the Constitution, laws of the United States, and treaties made by the United States are the supreme law of the land. All right, a sixth principle is the fact that we have representative government that is chosen by the people. And it's expressed in Article 1 of the Constitution, which requires that all representatives in the House be chosen by the people, and in the 17th Amendment in 1912, which made senators elected by the people. Originally, senators were elected out of the state legislature. So under this idea of representative government, we should mention the idea of one man, one vote, which affects the drawing of lines between congressional districts. Keep in mind that representation in the House of Representatives is according to population. And so states are assigned the number of representatives that they're to have in the House, and then it's up to them to draw the lines. So after each census, if people have moved around in the United States, some states may gain seats in the House and others may lose seats in the House. So that 435 members in the House is all apportioned depending upon population. And so when population moves, then every 10 years, some states may gain seats, some states may lose seats. In the 1960s, many of the state legislatures were not drawing up the districts very well, so we had what are called malapportioned districts. So in Tennessee, for example, one county had about 2,000 voters, and they got to choose a representative. And then another county had 312,000 individuals, and they got to choose one representative. And so you had a disproportionate amount of people in each district voting. So one representative represented the interests of 2,000 people, and another representative represented the interests of 312,000 people. So this is an idea of unbalanced representation. So now we have laws in place to deal with how big each district is, so there's really one man, one vote. We'll deal a lot with this issue of apportionment when we talk about the House of Representatives. All right. A third principle is the concept of judicial review. The Constitution implies that a court, the Supreme Court, can declare the laws and actions of public officials, including the President and Congress, to be invalid if they conflict with the U.S. Constitution. It's also implied by Article 3 that the federal courts have the power to deal with cases arising under the Constitution and consider the validity of laws made by the legislative branch. And judicial review was spelled out in the Supreme Court case of Marbury v. Madison. And these are the key players: John Marshall, Thomas Jefferson, John Adams, and William Marbury. And so I'm going to show this clip, and hopefully this will work on, I've never tried this with the taping, so we'll see how well this works out.
Jefferson was building a country, and he had a very extended vision of where things were going to go. And I think he became pretty hardcore about people who got in the way. And he saw Marshall as someone who was getting in the way.
The swearing in of Thomas Jefferson has got to be one of the great ironic moments in American history, because you have Chief Justice Marshall swearing in his second cousin, Thomas Jefferson, and both men pretty much by that time hated one another. They feel that the policies represented by the other person was detrimental to American civilization. It was as fundamental as that. So you have Marshall holding the Bible, Jefferson swearing to uphold the Constitution, which Marshall was absolutely sure he was going to destroy.
The first fight between Jefferson and Marshall was a fight picked by John Adams on his way out of town. That quarrel would spill into the United States Supreme Court. On paper, Marbury versus Madison involved a small technical question of administrative housekeeping. But in the political swirl of 1801, this seemingly straightforward legal case would determine the future of the court and test the cunning and ability of the new 45-year-old Chief Justice. Marbury versus Madison began with another breathtaking act of partisanship by the outgoing President John Adams. Just weeks before Jefferson's inauguration, the lame duck Federalist Congress had passed legislation swelling the federal courts, and Adams stuffed them full of anti-Jeffersonians.
At the very end, literally the last day of Adams' presidency, he was busy signing commissions for these federal judgeships, including these justices of the peace. And the hour got very late, and he had to get the commissions signed, and then they were sent over to the Secretary of State, who happened to be John Marshall. And Marshall had to put the seal of the United States on it, and then they were to be delivered to these designated justices of the peace.
John Marshall knows he can't deliver them all. He gives about half of them to his brother James to deliver. James doesn't get around to delivering them before time runs out. The key lesson of Marbury versus Madison is don't give important documents to your brother.
All right, well, that was just the background of what happened. So what Marbury wanted was his commission to be delivered, and this led to a Supreme Court case that said that the U.S. Supreme Court had the right to review acts of Congress and the legislative branch, giving them the power of judicial review. We'll talk a lot more about judicial review when we do the unit on the judiciary. All right. Another principle, and again this is the focus of next week, is the principle of federalism. This is the idea that you have a division of political power between the states and the federal government. But remember, the federal government, it trumps, if you will, has a supremacy clause. And so states under the Constitution, and although this new Constitution was supposed to give it more powers than what they had under the Articles of Confederation, the states still remain independent even under this new Constitution. So things like public education, although it's subsidized by the federal government, each state is allowed to have different standards, for example, for teachers. Each state has their own laws concerning birth, death, marriage, and divorce in terms of documentation. They each can conduct elections at the state level with different rules and with different legislative acts. The states are responsible for setting up local governments. So the city and the county, they have their own districts and the school districts and the library districts. So the states have control over that. States also exercise what are called police powers. And those are those types of powers that are designed to protect and nurture the safety, welfare, and morals of the people that live in that state. So this is a division of power between the national government and the state government. All right. Lastly, it's important to note that the Constitution is flexible. The idea that the people of the United States should be able to work out any problems in the government system after it's been established or change with the times, if you will. So the forefathers recognized that we need a way to amend or change the Constitution. And so changes can be made in the Constitution by the amendment process, and there's 4 different ways really to ratify the Constitution. Okay, so the proposal, a Constitution can be proposed in one of two ways, and it can be ratified in one of 2 ways. And so the next slide, well, momentarily I'll have a lot more to say about the amending process. All right, if we think about what all's going on in the Constitution, we can see that the next several weeks we'll just start talking about each one of these articles. So after the exam, we'll start talking about the legislative branch and a little bit about the executive branch. We'll talk a lot about the judicial branch. So each one of those articles gets basically their own week. We'll talk a little bit about interstate relations in terms of next week, where I have highlighted the federal-state relations. So next week is when we'll talk about federalism. Okay. All right. kind of in general, if I wanted to summarize what the Constitution provided, it gives the country some national unity and power that the Articles of Confederation failed to do. Remember, the Articles of Confederation was a failure because of the lack of federal power. So the new Constitution had to balance this power structure between what the states were going to be able to pursue and still be able to have a unified nation, to have a unified economy, for example, as well as deal with issues of defense. So the states were given a lot of power, but were asked to respect each of the other states in the Constitution, and the Constitution would then be the supreme law of the land. The Constitution also, from the state's perspective, had to limit the power of the national government. This is why we have the separation of powers with those checks and balances, because we have the constituents are divided to make office holders accountable to different elements of the people. So, for example, we elect people to the House of Representatives, but we also, those same constituents, elect people to the State House of Representatives. So we send people to Washington, D.C. to represent us in the federal government, and we send people to Austin, Texas to represent us in our state interests. And that's really at the heart of federalism. And then the Bill of Rights was passed in order to ensure that that the government was indeed limited in what it could do to the citizens. All right, let me just show you a few ways that the Constitution can be amended, and then we'll close. All right. So just keep in mind that there's really two ways to propose an amendment and two ways to ratify the amendment, so that, let's look at box A. If the proposal is made at the national level, then passage in the House and Senate each by 2/3 of vote is required. But after that, it can be ratified in one of two ways, either by the majority vote in the legislature of 3/4 of the states, or accepted by conventions called for the purpose in 3/4 of the states. So you can see that the different routes are possible. A can go into C, or A can go into D, so that gives you route 1 and 2. If the proposal comes from a national convention called by Congress in response to petitions of the states, then again you have two routes. Generally speaking, the amendments come through box A and then go into C and D. So just be aware that there are 4 ways to amend the Constitution, or 4 different routes. But basically, the amendments have to be proposed and passed by 2/3 each of the House and Senate, and then accepted by the states. So again, that's that federalism at work, where you have the federal government proposing legislation and the states ratifying it. All right. Here are some of the different amendments to the Constitution. Of course, the Bill of Rights, Amendments 1 through 10, we will deal specifically when we talk about civil liberties and civil rights. Then we have a variety of different types of amendments. The 13th, 14th, and 15th Amendment are what are called the Civil War amendments. And then we had the national income tax right before World War I. And here is the amendment that deals with extending rights to women. That's the amendment number 19. This 22nd Amendment deals with limiting presidential terms to 2 terms. And this amendment, the number 26th Amendment, extended voting rights to citizens aged 18 and over. And so you can just see here the Constitution has only been amended 27 times. So while it's still quite flexible, it's what is called an enduring or living document. And the number of times it's been amended has been minimal, given its over 200 years of existence. All right, I just want to say a few things about the Texas Constitution, and where you should focus in on is how it is similar and different than the U.S. Constitution. The state of Texas has been in business as a state since 1845, and during that period, even before that period, in all of its history, there have been 7 constitutions. So while the United States has had 1 constitution, the state of Texas had 7. The first one was the Mexican Constitution of 1824, and then the Republic of Texas had its own constitution. Then after it was adopted into statehood in 1845, that's the 3rd constitution. It had a fourth constitution when it joined the Confederacy in 1861, and then it had a fifth constitution in 1866 when it re-entered the Union, and then it had a fourth in 1869 during the Reconstruction period, and finally our current constitution was written in 1875 and ratified in 1876 at the end of the era of Reconstruction. So let me just say a few things about how these documents are similar. One similarity is that the Texas Constitution provides for 3 branches of government, just like the U.S. Constitution. We have a legislative branch in the state of Texas, we have an executive in the form of a governor, and we have a judicial branch. One difference is that in our Texas Constitution, we provide for 2 top judicial courts. So instead of having one Supreme Court, the state of Texas has 2. One is called the Texas Supreme Court, and the other is called the Court of Criminal Appeals. Another similarity is that the Texas Constitution also has a Bill of Rights, just like the U.S. Constitution. It guarantees religious freedom and the separation of church and state. It provides for the freedom of speech and the freedom of the press. And it even has a Texas Equal Rights Amendment that was passed in 1972. The United States Constitution does not have what is called an Equal Rights Amendment. A big difference is that you're not going to find the Texas Constitution in the back of your book, mainly because it's extraordinarily long. The U.S. Constitution has 8,700 words in length. The average state constitution is 26,000 words in length. The Texas Constitution is over 62,000 words in length. It's the 4th largest in the nation. So one of the problems is that it has a lot of laws that have never been taken out of the Constitution, even though they're no longer in effect. The Texas legislature only meets every other year, and so they don't spend a lot of time deleting things from the Constitution. They spend a lot of time adding things to the Constitution. Another difference is the Texas Constitution is easier to amend, and it's been amended many more times, contributing to the length of the Constitution, of course. And we'll talk more about that a little bit later. All right, so those are just some similarities and differences just to introduce you to the Texas Constitution. All right, that's where we're going to conclude talking about the principles of the U.S. Constitution. Make sure you review the reading questions and key terms that are posted, and of course you can replay any of these lectures at any time up until the first exam. There are practice quizzes in the text as well as at the norton.com website for this particular textbook. All right, I'll see you here next time when we talk about federalism.